House Bill 815, a bill relating to method of execution, reported from the Committee for Courts of Justice, and there are 2 floor amendments.
The senator from Eastern Fairfax County, Senator Surovell.
Thank you, Mr. President. Move to waive reading of the floor amendment.
The question is, shall the reading of the floor amendment be waived? All in favor of the motion will say aye. Those opposed, no. The ayes have it. The reading of the floor amendment is waived. The senator from Eastern Fairfax County.
Thank you, Mr. President. Speaking to the floor amendment.
Sorry, Senator.
Speaking to the floor amendment.
Senator has the floor.
Thank you, Mr. President. And ladies and gentlemen, in case we haven't had enough non-controversial issues today, we have another one right here in front of us today in House Bill 815. As I'm sure you all are aware, House Bill 815 basically makes the electric chair the default method of execution in the Commonwealth of Virginia in the event that we're unable to procure the drugs that necessary to extinguish human life. My concern, I have many concerns about this bill, I'll talk about when we get to the bill itself, but what this floor amendment attempts to do is to introduce some transparency to this process. If you look at the bill, it's actually pretty simple, and it's incredibly vague for something so important. The existing bill basically says that in order to skip a prisoner's choice of lethal injection and require them to be executed by electrocution, the director of the Department of Corrections has to certify that the method of execution chosen by the prisoner as set forth in this section is not available for any reason. And that's all they have to state, is for any reason. No specificity whatsoever. What this floor amendment does is it puts a little sunshine on this process. It says that if the director is going to make that certification, the director has to provide some information. Number one, the director has to set forth all reasons for his determination that execution by lethal injection is not available, including the lack of lethal substance necessary to perform the execution. And 2, the director is required to describe the efforts the Commonwealth has made to obtain the necessary substances, including a list of the pharmacies, manufacturers, other entities that were contacted in order to try and comply with the statutory mandate. It then says that within 24 hours of making that decision, that certification should be placed on the website for the Department of Corrections. It should be given to the governor. It should also be given to the chairman of the House and Senate Courts Committees so that everybody's aware of what's going on. It creates some transparency and some information so that we, the public, so that Virginians can judge whether or not, in fact, the government has exerted enough effort in order to get to this point. Because if you just read the bill, the language of the bill itself, it says any reason, any reason. What could that reason be? Suppose the director of the Department of Corrections doesn't feel like going to get the drugs, doesn't want to go get the drugs. Suppose obviously one reason is they might not be able to get them, but it could be any reason. Suppose they're out of needles. But we need to have some transparency on this process. We're talking about the execution of a human being. And that's basically all the amendment does. It inserts some transparency in one of the most weighty things the government does. I think it's a good amendment, and I would hope the body would support it.
Thank you, Senator. The senator from Rockingham, Senator Obenshain.
Mr. President, speaking to this amendment, it would be my hope that the members would vote against this. And let me lay a little bit of the backdrop against which this bill was introduced. You know, I've had an opportunity for the past couple of years to vote on this bill, and for the past couple of years, I've voted against it. I've voted against this piece of legislation because I thought that we could get the execution drugs, that we could go through the steps necessary to obtain the materials necessary for the most humane method of carrying out capital punishment possible. However, I support it this year, and let me tell you why, and why this amendment is wrong and will not work. there has been a concerted effort and really very effective effort by opponents of capital punishment. And I understand there are deeply held views on whether we ought to keep capital punishment or not. But the opponents have decided that their most effective method of or tactic in this fight has been to go after the companies that provide the drugs that are utilized for humane executions. And they've done this in a really effective way. They've organized boycotts of these companies. And these companies, you know, they sell a couple of vials to a handful of states a few times a year of these drugs. And they're faced, on the other hand, with boycotts involving tens of thousands, if not millions of people around the world who utilize this or fall into line with these efforts. And the companies have decided we're not going to sell to states like Virginia at all unless they will certify that they will not use any of the drugs listed for purposes of executions. And what this has done is it has created an environment in which we cannot get these drugs. Now, last year, there was an effort to have a piece of legislation that allowed compounding pharmacies to create these drugs, which was a good idea. However, it got derailed because of well-intentioned transparency legislation. And you know and I know what that was for. The reason that that was offered was so that, again, the opponents of capital punishment could identify those compounding pharmacies who are compounding these drugs to provide to states like Virginia for purposes of carrying out humane executions, and the providers of the component drugs so that they could protest and boycott those as well. And this is just another in that line of amendments. This requires a list of all pharmacies, manufacturers, and other entities contacted. Now, the whole premise behind this amendment, presumably, is in part some thought or suggestion that the Department of Corrections really would prefer to use execution or execute by means of the electric chair. Now, you know and I know as well that that's the last thing in the world that the Department of Corrections wants to do. The Department of Corrections is going to go and has gone to great lengths. And I tell you, I am a little cynical about some in the political class around here, and I have policy differences, and I may question the representations that some may make, but you know what? I had a great and very productive sit-down with the Secretary of Public Safety. And we talked about the efforts that the Commonwealth has gone to secure these drugs. And I am completely convinced at the good faith, the determined efforts made by the administration, in this instance, the Secretary of Public Safety, to secure these drugs necessary. But this amendment does not make this bill better. This amendment is going to essentially do the same thing as the efforts to boycott. It will further the efforts of those who would boycott providers of these drugs. It would undermine further our ability to secure these drugs. And in a way, it is the result of this is it's a perverse result in that the opponents of capital punishment are making it impossible for us to carry out executions in the most humane means possible. So you put this amendment on here, and I can guarantee you that it makes it more likely rather than less likely that executions will take place with the electric chair as opposed to lethal injection. So if the debate is over whether we can keep the death penalty, let's have that debate. Let's have that debate. But this is not that. We have the death penalty, and this simply provides the Commonwealth with the means for carrying out hopefully provides incentive for us to carry it out in an appropriate way, and this just undermines our ability to do that.
Senator, the senior senator from Loudoun, Senator Black.
Thank you, Mr. President. Speak to the measure.
Senator has the floor.
Ladies and gentlemen, I know there are differences over the death penalty and the advisability of it, but let me just point something out to you. During my time in the Pentagon, I was personally responsible for all death cases within the Department of Defense. And having worked very diligently through those cases, first I will tell you, there is nobody on death row because they got involved in a barroom brawl and smashed somebody's head with a bottle. The people who are on death row have done things that are beyond discussion within this particular body. But I will tell you that having worked very, very hard on this over many years, if we add any sort of a qualification to the manner that we're going to carry this out, we will create a means of litigation. And when you're talking about litigation in the capital arena, the courts are reluctant to disregard even the most fanciful of arguments because they want to make sure that anyone who is put to death has had absolutely every conceivable opportunity to make their case. And so as you vote on it, just be aware that if we add this, it would not surprise me if this one simple measure adds 4 or 5 years to the time that it takes to carry out an execution. This has been our experience. Anytime you complicate the system, you attenuate it, and you make it that much longer that you have these people waiting, and you have the people of the Commonwealth waiting for justice. So I oppose this particular amendment.
The senator from James City County, Senator Norman.
Thank you, Mr. President. I rise to speak against the adoption of the floor amendment,
Senator
sir.
has the floor.
Ladies and gentlemen of the Senate, as I reflect back on my otherwise undistinguished career as an attorney, I think when I came into the General Assembly that I had tried more capital murder cases than any lawyer in the Commonwealth of Virginia. And so this is a subject that I have professionally and personally and politically reflected on over many, many years. And I was taken by the comments of the senator from Loudoun. We can have a continuing debate about capital punishment and whether or not it is an appropriate policy decision, but that is not what this bill is all about. I was very interested as I read the proposed amendment in the number of ingredients that were trying to be inserted into the bill as it now exists. And I also recall that one of the things that defense attorneys ethically must do is to assert every reasonable defense and inquiry in the protection of the life and liberty of their client. And my concern is that with the interjection of these provisions in there, that we are providing additional areas of a collateral attack on the efficacy and the continued enforcement and adherence to a decision that has been deliberately made by a jury or by a judge after having considered all the facts and circumstances. I remember the very spirited debate, if not outrage, many years ago when I introduced some legislation that resulted in reducing the period of time where the rights of a defendant who's been convicted of capital punishment could be adequately protected, but that it reduced the period of time from approximately 15 years following the date of judgment to 7.5 to 8 years. And there was a lot of debate about it at that time. The senator from Loudoun mentioned the period of time that can take as you exhaust these appeals, and no one is seeking to deprive that convicted defendant of his or her constitutional rights and the protection thereof. But I am suggesting to you that based upon my experience, that whether it is an intended or an unintended consequence of this amendment, that it is going to interject into this entire consideration of capital punishment on appeal and the carrying out of the decision of that jury or that judge. It is going to extend the period of time, and it is going to afford the basis for additional attacks. And by the way, Virginia's capital punishment statutes, including the carrying out of the judgment of the court, has been attacked many, many times, and the reason that the legislature has been reluctant to change any portion of it is because it has withstood every constitutional attack. And to put additional elements into that is only an invitation for additional constitutional and collateral attacks, so I would encourage you to vote against the amendment.
Thank you, Senator. The senator from Southern Fairfax County, Senator Barker.
Mr. President, speaking to the amendment.
Senator has the floor.
Mr. President, I believe that I agree with the senator from Eastern Fairfax in that whether or not this amendment is adopted, I plan to vote against the bill. My concern, however, with this particular amendment is that I agree with the senator from Rockingham that if this amendment is passed and then the bill is passed, what it will do is it will further complicate the ability to use the lethal injection method in implementing the death penalty and will actually result in all or nearly all of the executions being done by the electric chair, which I think is much less desirable than the lethal injection method. I hope, therefore, we would defeat this amendment.
Thank you, Senator. The senator from Eastern Fairfax County, Senator Surovell.
Thank you, Mr. President. Speaking if nobody else is in the queue.
Senator has the floor.
Thank you, Mr. President. Ladies and gentlemen of the Senate, let me just make a couple things clear. If we pass this bill today, with or without this amendment, this thing's going to the courts for a long time. Because we are changing the statute that has been litigated repeatedly, and we are interjecting a new element into it. And whether this amendment's adopted or not, this thing is getting litigated, because we are fundamentally changing Virginia's execution laws if we pass this bill today. And I'll deal with that in a second after these floor amendments are dealt with. Number one. Number two, all this amendment does is interject some transparency on this process. That's all it does. Why do we need transparency? I'm sorry, but I don't trust the Department of Corrections. I don't. We debated legislation last year carried by the senior senator from Fairfax County. You all voted on it here. It passed out of this body, went over to the other body where I happen to be. And that legislation proposed to say the Department of Corrections didn't have to tell us what drugs they were using to kill somebody. I was involved in a floor debate. That bill died with 33 Democrats and 28 Republicans voting to kill it. It was a bipartisan effort voting in favor of sunshine, voting in favor of disclosure, voting in favor of taking government-sanctioned death out of the shadows and doing it in a way that had some measure of transparency about it on a bipartisan basis. That's all I'm asking to do here. And I would note for the body, one of my favorite quotes is Justice Louis Brandeis, Wisdom for the Ages, in which he said, a spotlight is the best policeman, a streetlight is the best policeman, and sunshine is the best disinfectant. When you provide information, and you allow people to look at it, and you allow our taxpayers to see how their dollars are being spent and how the government is doing its business, you get better results and you get better outcomes. That's all this does. And that's all I ask for. I'd hope that you'd vote for the amendment.
Thank you, Senator. The question is, should the floor amendment be agreed to? All in favor of the motion will say aye. Those opposed, no. No. The noes have it. The floor amendment is not agreed to.